It's 30 minutes, Honorable Sauls.
Thank you, Chair. Advocate, good evening to you.
Evening, Honorable Member.
Let me begin by saying that, firstly, it is very refreshing and it's a proud moment to see a Black Indian African holding your position and expressing so much bravery as a female fighting against corruption. You know, it gives hope to people like Babita, the late Babita, was no longer with us, Paul Malife, Pamela Mabini, Over van Niekerk, and there are many others whom your efforts will assist in bringing closure. So for that, I'm thankful. In the same breath, I want to take time to express my utter disappointment in the fact that out of 128 staff members, there's only 3 colored Africans. It's disappointing. And you have 18 white Africans, 91 black Africans, and 16 Indian Africans. I'm very intentional about calling everybody Africans. But that's the posture of our country, and we're not surprised by that. I mean, earlier, Honorable Malema, when we made that statement, he made a comment justifying such. Honorable Breitenbach laughed in support. I didn't find it funny when it came to Coloureds. And I didn't call on the chair to call him to order or for him to withdraw. Because in our country, we've realized no one is coming for us. We must rise up ourselves. So, colored South Africans will rise up for ourselves.
Honorable Sauls, I see the hand of Honorable Matthias is up.
Chair, it's just on a point of order. Honorable Sauls is bringing up something that was not done or said or anything on record. Nobody heard it. It was an inside joke. And I don't think it needs to come here and be made public. It was not said. Nobody said it out loud. And if he felt some type of way, he could have just dealt with that privately. It wasn't done during this committee and on mic. So he must withdraw. It's unnecessary. Did anybody hear it? It's not anywhere on transcript or anything.
And Chair, she's not denying that it was done. And I said that the reason why I didn't call for it to be withdrawn is because we're no longer begging and asking for such to be withdrawn.
But Honorable Sauls, you can't ask for something to be withdrawn if it's not on record. If
it was said.
It's not there. It wasn't said to the committee.
But it was said and I heard it.
Honorable Matthias, well,
do not talk down on Coloureds and think it will be okay. So I'm addressing it, Chair. I don't think I'm out of order. It was said even though it wasn't heard. Unless the honourable member can deny that it was said.
The matter which you speak in reference to, was it said off record?
It was said in the House. It was not said on the mic.
Yeah.
So I heard it. And I said that the reason why I'm not calling for it to be withdrawn is because we're no longer asking for withdrawal.
Yeah, no, where I'm sitting, I'm powerless to adjudicate on a matter that is off record.
Chair, I'm not seeking your intervention. That's what I'm saying. And we are not seeking...
Yes, but what the honorable members is saying, she's correct, because it has not been read into the record of the proceedings.
Chair, I was speaking through you to the witness, and I was addressing the employment equity. And in my statement to the witness, I mentioned that. I was not asking for intervention.
It's fine, honorable members. Let's get back to the business.
No, Chair, but there has to be a point of order, because he's going to leave here and the whole of South Africa is going to have some type of version of something that was not said in this committee, that was just said in power. We joke around here all the time.
Don't joke
and
about
if you
colours.
did not like it, so what am I also?
So don't allow your leader to
There's
joke
nothing
about
to
us,
allow.
you and me.
But it wasn't like that. But at the point here is that you and I can have this discussion after. We are here in a committee, Honorable Sauls. That thing was not said, and you bring in something where it shouldn't be. There's nowhere on transcript where you're going to hear that. So I'm just saying, use platforms properly. You always come here and you abuse platforms. Yesterday you were abusing this platform, dealing with issues that's dealt with on social media. Then you come and redeem yourself here, and we just let it go. Now you're doing the same thing on something that is said behind the scenes. Come and call me out after. There's no problem. We'll talk about it. Thank you.
But Chair, I didn't say anything on record. I'm sitting here with an undisputed Coloureds. You could have heard that.
I'm not going to call you to order. You should call your leader to order. May I continue, Chair?
Who else wants to speak? Raise your hands, those who want to speak. Yeah. Because look, if you want us to discuss a matter which is not on the records of these proceedings, anyone can as well bring any other matter. I think at that point, Honorable Sauls, in all fairness, if there was something that you had, you could have brought it to the attention of the chair to say there is this remark that is being made, Chair, and I think it's uncomfortable with me. It's bringing discomfort on my part. Can I please raise it with you, and then you rule over it? And unfortunately, you allowed it. And then at the time we give you chance to speak, you want to go back to it. And that's why I'm going to rule you out of order, because that matter is not in the record of our proceedings.
Chair, I'm going to use the opportunity to challenge your ruling, because I was not asking for your intervention. I was addressing the witness through you. I was dealing with the matter that I'm disappointed that there's 3 Coloureds. Then, as I'm speaking to the witness, I addressed what I heard. And I was clear that I'm not seeking the intervention of this House or anybody, because that's the reality of colored people in this country, but we're not begging no more. We will do it for ourselves. No one should withdraw.
Let me tell you what my approach is going to be. I am not going to be technical about the arguments. I want you and us take an approach that makes the proceedings to move forward. It's your time now. You can question the witness.
Thank you, Chairperson. Honorable Advocate, I hope that my expressed disappointment is heard by yourself as it relates to the fact that there's only 3 colored Africans employed there.
I take note, Honorable Member. However, we have no control over who applies for positions, and it is our unfortunate reality that the majority of those who do apply are not of the colored disposition, especially within the framework of criminal and financial investigators. And that is the reality that we were faced with, and that is the appointments that we have. I can't change the numbers. I do, however, understand your misgivings about the low numbers. But people have to apply, people have to qualify, people have to have the requisite relevant experience, and regardless of their color, they would then go through.
Although I don't want to belabor the point, but we need to do more to get the word out there. There are many that would qualify. And so I'm not going to belabor that point, but do more, advocate. General Mkwanazi testified that the arrest of General Khumalo was an attempt to protect drug cartels. And when they looked at the dockets and realized that it had nothing to do with Gauteng, it was KZN, he then said it's for that reason that they now diverted an attack towards General Khumalo. And obviously because it was IDAC, he was referring to you. Is that true?
It's completely false, Honorable Member. What I do recall is that in media reports, which I indicated, we became aware of investigations into Mr. Matlala and Katitso Molefe. What I'm aware of is, as those reports say, they are charged for the following: attempted murders, conspiracy to commit murders. I'm not aware of any drug charges. And even if they were, they are of no interest to IDAC because those do not fall within our mandate. And having an interest serves no purpose. So we were not aware. And I can only go on what they were charged for. They're not charged, from what I recall, unless the media reported half a story. There are no drug charges that were brought against those two. I'm not saying that there's no evidence and no charges may be brought later, but at the stage at which IDAC conducted its investigations into the head of crime intelligence, that is not the reason why we conducted our investigation. We have no issue with Molefe or anyone else that deals in drugs. Those must be dealt with. It is an ugly reality.
General Khumalo is charged. The charge is fraud and corruption related to the irregular appointment. Can you unpack the impact of this practice and how would this irregular appointment possibly assist in corruption? Because the reason why you're involved, it's not just an irregular appointment. It's the fact that it's related to fraud and corruption. So in practice, just explain to us practically, how would this appointment assist in corruption?
So, Chair, this appointment, and I have to back reference it to matters that arose out of the State Capture Commission. When you have people who are beholden to the person who has gratified them by virtue of an employment in a position they would not have gotten because of the lack of requisite skill and or knowledge and or expertise or qualifications, it makes that person be placed in a strategic position in which she was placed. Putting people in strategic positions, and especially where there's money to be made from procurement, where systemic processes can be bypassed, investigations can be run as they want to be run. The TSS is a very volatile environment in terms of what they can do, the kinds of equipment they sit with. And so the things that the Honorable Malema indicated that become a worry for a citizen are the kind of things that can happen when you put the wrong people in place. And that is the worry. The impact is not felt with that immediate appointment. It is as the time passes and the opportunity arises for those who put that person in that position of power that you see it. Some of the impact you can't reverse. We've seen that in terms of what had happened with state capture.
Furthermore, the charge is centered around alleged flouting of the vetting process. Explain to the nation the impact of this. Is it a mere administrative error or a fundamental breach of national security?
So it wasn't a mere flouting of process. without going then into to the actual evidence, what they sought to do in this process was get someone vetted, not on the system that we use. They actually tried to get her details onto an old system so that her lack of pedigree for a vetting could not be traced. In an environment that is crime intelligence, it is even more sensitive, I would say, than IDAC. All kinds of things can happen unchecked. And so vetting must be done. But this is not the only person. Hence, we have those other matters, Honourable Member, that were referred in terms of the Section 27 referral that are also being considered for the bypassing of vetting, where people failed the vetting, remain in their positions, and were brought into strategic positions within crime intelligence. It has a big impact.
So it is a fundamental breach of national security. It's not just a mere administrative error.
You are correct.
If you agree that because General Mkwanazi has someone in your office that is reporting to him information in your office, if you agree that it's indicative of rogue elements within the office, and General Mkwanazi is actively communicating with this person, asking for information, would you then say that General Mkwanazi is the initiator and active participator in the creation of these rogue elements?
Yeah, I'm being cautious with my answer only because I don't know who it is. It helps when you know who they're talking about, because then I know who we've worked with, who this person is, what this person had access to, what could they have given, allegedly given General Mkwanazi. But of course, the fact that he said, we did not say, General Mkwanazi under oath said he has sources in IDAC, it is a problem. It is a real problem. And I indicated it's not just about IDAC. As law enforcement, we shouldn't be seen to be wanting to have sources giving us information when at his level and mine, we should have been able to talk to one another about whatever it is he seeks to source from his source or sources. That is where we have that big shortcoming in terms of how law enforcement operates with one another. There should be trust. As ugly as my truth may be, I should have the comfort, as I do call the National Commissioner, for General Mkwanazi to have been able to call the investigating director. And last thing, Honourable Sauls, maybe he decided, well, I don't like the young lady, I'm not going to call. There is the National Director, there is also the Minister of Justice. And whatever it is he wanted, he could have escalated it there. He did not need to have sources or a source.
SEP's legal services, in the exhibit that we were provided with, SEP's legal services reviewed the 7 dockets, and they concluded that it was, open quote, scanty and too vague, close quote, to formulate charges. Did IDAC, when you took the 7 dockets, did you come to the same conclusion?
First, IDAC had the Section 27 referral, which gave us more direction and substance about what was being alleged. When we got the dockets, those dockets were further investigated. So investigations had to be done, yes.
Yes, but the conclusion, was it the same as the conclusion that the SEP's legal services came to after they reviewed the dockets? Did you come to the same conclusion after you looked at it, or was it different?
So we didn't draw a conclusion per se on the dockets. We looked at the dockets and concluded that further investigation needed to be done. And that is what we did.
Yes, but when you looked at it, are you saying upon looking at it, upon investigating it, SEP's legal services says when they looked at it, it's too vague, it's scanty. There's no need for charges here. When you looked at it, are you saying there is a need for charges when you looked at it?
Sorry, Honourable Member, we said there's a need for further investigation. Their assessment and ours are different. We apply different minds to a matter, same like prosecutors do all the time. When we adjudicated over it, we said more work has to be done.
So you disagree with their conclusion?
I don't know what all they assessed when they arrived at their conclusion. I don't want to say that they are wrong, especially more so, Honorable Sauls, when we didn't know that they were even conducting such an exercise. They were looking at why his matters were not being investigated. So what they apply their minds to in terms of what is merit-worthy and or not, and why they perhaps didn't conclude as we did, that there should have first been further investigation. And maybe I should pause. That is what they perhaps sought to do by wanting to have an interview, conversation, or engagement with Mr. Adams. They tried on several occasions, and he did not respond. It means they wanted to do more. They couldn't do more because the person that they needed to talk to had not availed himself. I don't think we arrived at it differently. I think they had to deal with what they had. We had access to Mr. Adams, and he was able to give us more.
Does that mean you also consider it vague?
I didn't look at the dockets. So the investigating team and prosecutors looked at the docket and asked for further investigation. If you want to say that that is why we did further investigation, I'm saying when you looked at it, there was enough to point you in a direction to conduct further investigation.
Yes, which is contrary to what the legal services of SEPS has concluded. So it is, I think it's okay, advocate, to say that their conclusion is different than yours. And yours is that it warrants, you don't say charges, but you say it does warrant more investigation, which says the things that you have found on first glance points you to continue.
You are correct, Honorable Sauls.
Please explain to us, just in layman's terms, so that we understand, what is the chain of custody protocols of the handover of dockets? Take us concisely, step by step. If you now need to get the dockets from SAPS or wherever it is, from the inspectorate, what is the formal chain of custody protocols to do so?
So, Honorable Sauls, I am unable to explain the SAPS protocol, but in terms of the protocol that the IDAC would have had to adhere to, it is in fact what was done, which was write to the Divisional Commissioner of Detectives, as the detectives are the custodians of dockets, these being matters that the honorable member allegedly opened at police stations. We made the request. I'm not sure what internal process followed between Lieutenant General Sentomule, Lieutenant General Jacobs, and all those who had to then find and hand over the dockets. Part of what we had to ensure is that we got the dockets in their original form, which we did, that the statements that were in the A clip of the docket are what is referred to in the investigation diary, and that is so. There was nothing missing on the face of what was in A1 and what was recorded in the investigation diary, and that we were given, in fact, original documents. And in terms of our chain of custody, we are able to say where we got the dockets from in terms of who handed it over to IDAC. But between the letter written by myself to Lieutenant General Sentomule and the actual handing over of the docket, I'm unable to explain what protocol or process would have been followed, Honorable Chair.
On page 5 of 6 of the exhibit that we were given, on the 6th, it starts off from 6.5. Are you there?
Can you tell me, Honorable Sauls, what I'm looking for at the top of the page?
We are at MK15 page. At the bottom, it would be page 5 of 8, and at the top, it will be 2.7, and the other number is blurred out.
I am there.
Complaint against the South African Police Service.
I do have that.
6.5. It says on the 6th of December, Colonel Philip received a call from Mr. Rafase of IDAC, and he indicated he's coming to collect 6 dockets and the other one, the Valeria one, and that arrangements was made for him to come and pick it up. 6.5.1, Mr. Rafese produced an NPA document which was addressed to Major General Khumalo. Is that the one you've written?
Honorable Sauls, I had written to Lieutenant General Sentumule. I am given to understand that the investigator is Mr. Rapeso. Mr. Rapeso had been informed that he must make contact with Colonel Philip. What I assume he would have done is, in order to acknowledge receipt, he would have drawn up a document that would say what he was receiving and from whom, and putting down those dockets. He didn't need my permission for that letter. The ID only wrote one letter herself, which was to Lieutenant General Sentumule. I'm not disputing that there was another letter, but I did not write it.
Well, the information we have is not the one you have written. The information we have before us that's submitted, it is said that the letter that was produced, an NPA letter is how it is phrased, NPA document, and that document was addressed to General Khumalo. Do you accept that?
I accept that, Honorable Member, and the reason it would be an NPA document is Mr. Rapeso is in IDAC, and it's an IDAC NPA letterhead that we ordinarily use.
Sure, but we're addressing who it was addressed to. Your testimony says you, the letter you wrote,
Was to Sentumule.
yes, was to Sentumule. We're saying that's not what we have before us. What we have before us is that the document that was produced was addressed to General Khumalo.
I accept that there was also this document. I know that General Mkhwanazi did have sight of the letter to Lieutenant General Sentumula. In fact, I think it was attached as MK16 to his to the commission affidavit. So they were aware that there was a letter from the ID to Lieutenant General Sentumule.
No, I'm not disputing that, Advocate. I'm merely just dealing with the evidence before.
I accept that.
So what we have before us says that this was addressed to General Khumalo. In response, Colonel Philip says he's not going to accept that because it's not addressed to the directorate or to the inspectorate that he's responsible for, that heads the dockets. Do you accept that?
Accept that.
Was Colonel Philip correct in refusing?
At his rank and level, I accept that he would have had some trepidation. He didn't, according to how I read this, have the authority which he was seeking from Major General Khumalo, whom I assume is the provincial head in Gauteng. And how it usually works is they first seek permission. So there's nothing wrong in him wanting to confirm that he, in fact, can hand this over.
So he followed procedure.
In terms of what he set out here, yes.
Was it correct for Mr. Rafese to only show him the document but not give him a copy?
Incorrect. If you are in possession of a letter, what should happen is you have the original letter, you should have a copy of the letter, and the original should be handed over to the person you are engaging with, and they can acknowledge receipt on your copy, which is the ordinary process of how we engage, not just about dockets. When you send documents, wherever it may be, that is out of IDAC.
I refer you to 6.5.1. It says the NPA document was not handed over, it was only produced.
I see that, and as I indicated, Honourable Member, all of the documentation attached here to including this, I had sight of it for the first time when Council handed it to me today.
Yes, but you are testifying that the representative of IDAC did not follow proper process.
I can't dispute that he did.
You're saying he did not.
He did not follow process, and that is something that would have to be addressed.
And then when Colonel Philip tells him, you gave this thing is addressed to the wrong person, you must address it to me because we have the documents or the dockets and it's with legal services. Mr. Rafese then goes back and then he returns on the 9th. (653) says Colonel Philip informed Mr. Rafese that the dockets could not be handed over as the NPA correspondence was not addressed to the division inspectorate and that the dockets were with legal services. Mr. Rafese indicated that the NPA correspondence would be amended and arrangements were made for Mr. Rafese to meet the divisional commissioner on the 9th of December at 12 o'clock. And so he comes back. The 6 criminal documents were received back from legal services on the 9th. And on the same day, Mr. Rafese attended the arranged meeting and produced another NPA document, which was addressed to the Deputy National Commissioner, Crime Detection. He's told who to send it to or address it to. He comes back 3 days later and addresses it still to a different person, to Crime Detection instead of to Colonel Philip in 6.7. Was that correct?
Was incorrect.
So you are testifying that the official from IDAC was once again procedurally incorrect. He did the wrong thing.
Was procedurally incorrect.
Sorry, advocates.
He was procedurally incorrect.
Then 6.8, we're almost there. The NPA document was not handed over, only produced. 6.8, Lieutenant General Jacobs chose not to hand over the dockets as the correspondence was not addressed to the division. So would you now say, advocate, that on all these occasions, you testified that Mr. Rafese was procedurally incorrect, which would now mean that Colonel Jacobs was procedurally correct in his refusal. Is that what you're testifying?
Colonel Philip in 6.5.2 was correct. And then Lieutenant General Peter Jacobs in 6.8 was also correct. Protocol is that if there's a request, they must be given either the original or the copy of the request duly, properly signed and addressed to the party who, and that is chain of custody. You cannot have General Jacobs give over something when the request is not directed to him. What proof do we then have of how we got it? Because that could be disputed.
My last one. Then 6.9. It says on the 9th of December, 2024, at 12:24, Lieutenant General Sentamule called Lieutenant General Jacobs and indicated that the dockets are to be handed over to IDAC. The call lasted 2 minutes and 9 seconds. There's a screenshot attached, and the dockets were handed over to Mr. Rafese, who acknowledged receipt for the 7 dockets. What this says is that Mr. Jacobs, as you testified, understood the chain of custody, held to procedure, refused to hand over the dockets. The only time he handed over the dockets was when he received the call from his superior. And on that point, he hands over the dockets just because of a command that he cannot question, but he did his job as you testified. Was that correct procedure for him now, or rather for his superior to command him, despite the fact that you're doing the right thing, hand over the dockets to the person who's doing the wrong thing procedurally?
So, Honorable Sauls, you will recall that what I did indicate about Colonel Phillips was he needed to engage his superior. I am sure that if he was able to get Major General Khumalo on the phone, and if the Major General said, hand over the dockets, he would have done that. It is therefore not unlike what happened in this scenario, where if in fact when this call took place, Lieutenant General Sentumule informed him to hand over the dockets. There's nothing incorrect because the letter had initially been addressed to her. She therefore has the authority to indicate that the dockets can be handed over. He didn't do anything wrong. He had an instruction. That is how I read it.
Yes, but the person who's calling him is not there. He's supposed to.
Your time has expired, Honorable Member.
Thank you, Chair.
Thank you so much. Honorable Sangwen.
Thank you, Chair. I'm so sorry, man. This thing of this issue fascinates me. Advocate Johnson, your letter to Lieutenant General Sentemule, when was it?
Let me check with. Are you making a
Follow up?
Are you making a follow up?
Follow up,
because
Chair.
it's now your time.
Follow up. I'll come back for my time.
That's what I want to ascertain with you.
Follow up.
Okay.
Thank you. When was your letter dated to Lieutenant General Sentemule, and what would have prompted your letter? Then how does it happen that your investigator is busy then going around manufacturing other documents in the process? Thank you, ma'am.
I'm going to answer you, and then I'm going to put on my laptop, Honorable Chair, to give you the date. I ought to have done that. When I wrote to Lieutenant General Sentumule, I don't know what processes followed internally. What I was made aware of by the investigators is that Mr. Rapeso was asked to make contact, is it Colonel Phillips, with Colonel Phillip, and that is what he did. In order for him to take receipt of the dockets, if the colonel handed it over, he would have had to produce and hand over a document. Ordinarily, that document would say, I so-and-so handed over these dockets over to Mr. So-and-so. That helps the chain of custody. It's not just protocol, it's a chain of custody issue.
Okay, yeah, I think you're getting me the date, right? Because I need to understand whether Mr. Rapese came back to you and said, oh no, my Major Khumalo document didn't work. Please write another one for me that goes to General Sentumbule, but then he then arrives there with another letter that's directed to DNC crime detection. There's something strange there.
I accept it may not make sense. He didn't have to come back to me because they had given him somebody that he was supposed to engage with. Correctly so, the person says to him, I can't hand it over to you. I need permission. He didn't get that permission. He was told to address his letter to somebody else. There's nothing untoward. He's got to come back and address the letter. Where I do sit with the challenge, Honorable Sangoni, is why did he not, on either occasion, hand over a copy of the letter that he had then, I would assume, authored on both occasions?
Honorable Matthys.
Thank you, Chair. Advocate, just to follow up on the issue, Honorable Sauls asked the question in detail about how SAPS handled the dockets that Honorable Adams opened and how IDAC did. So we have the same dockets with two different outcomes. Tell us how that can work.
The only reason, Honorable Matthys, that I can deduce is they were making attempts to get a hold of Mr. Adams. That is what is in these documents. So from what we would have done, conducting further investigations means engaging with the dockets, and follow-ups were in fact made on the 6th of January to take supplementary statements from Mr. Adams. I think that is what they were trying to do, and because they could not get a hold of him for whatever reason, they were correct that on what they had, it was scant.
Chair, just one more. So pretty much we're saying that because of Honorable Adams' unavailability to SAPS, they were unable to pursue the matter.
That is correct.
And then when it came to you, did you ask Honorable Adams why he did not make himself available to SAPS, or is it because you already had the application lodged with you that you just continued with it?
We were unaware, as I've indicated, that this was in fact escalated to the inspectorate, and the inspectorate also did not inform us.
Honorable Bangazita.
Thank you, Honorable Chairperson. No, I just want to be assisted on this issue of rogue versus whistleblower. When does one, where do you draw the line? Because here, the certain people within IDAC were sharing information with General Mkwanas. And I've heard that they've been actually characterized as rogue. Now, when Adams, Honorable Adams and others, especially those witnesses that need to be protected, share information with IDAC, they are whistleblowers. Where do you draw the line?
Honorable Chair, it's a difficult question to answer because I don't know what was shared. I also do not know the intent of the person who would have shared this information. It is difficult to make a call on what the person is, not knowing what it is they escalated.
Honorable James, Honorable Sauls, and the last will be Honorable Malema.
Thank you so much, Chair. Just a clarity-seeking question. You've rightfully so explained earlier on how an irregular appointment translates to corruption. Am I right? And this is a follow-up on Honorable Sauls' question to you with regards to drug cartels, when you said that that does not fall within your mandate.
That is correct.
And drug. So you don't see drug cover-ups, compromise statements, SAPS members embroiled in drugs, transporting of drugs, intercepting drug busts. You don't see that as being corrupt. But you see irregular appointments as being leading to corruption cases.
Honorable James, you make a sweeping statement and work on an assumption. If there is corruption, regardless of what the underlying nature of the offenses are, yes, we will look at it. What I understood from Honorable Sauls and what I understood from my reading of these individuals in the drug cartels is that they are involved in dealing in drugs and or possession of drugs. If there are law enforcement officials that sought to defeat the ends of justice or compromise those for corrupt intent, that must be investigated.
Thank you, Advocate. That wasn't your response earlier on. You elaborated now. Thank you.
Honorable Sauls, this is an exemption. For sure, you will understand that under normal circumstances, you cannot ask a follow-up on your own initiative. But look, I'm exempting you, and I hope that it does not become an example to other members. That's what I'm saying, that it's an exemption, Honorable Saul.
Chair, you are assuming that that's what I'm going to do. Both yourself and Honorable Malema. I'm not doing a follow-up on my questioning. I was going to comment on the whistleblower thing. But if I'm not allowed to do that, it's fine.
Honorable Malema.
Advocate, in the spirit of collegiality, when someone sends information to General Mkhwanazi at that level, and General Mkhwanazi requires something from you, within that spirit of colleagues, is it not that fair that he calls you, if that information implicates you, calls your senior in the form of NDPP or minister or anything of that sort? Is that not the correct procedure to follow in the spirit of killing those perceived divisions and factions and things like that? Is that not the correct procedure, to do?
That is correct.
Thank you.
Honorable Sangoni, your time starts now.
Thank you very much.
It's 10 minutes to 9. By 20 past, you must be done.
I shall. And I was saying to Advocate Johnson, I think all questions have been asked. But we must work. Advocate Johnson, will you be applying or at least raising your hand for consideration when the position of NDPP comes up?
Honorable Chair and members, I am aware that the position is now open. I'm aware that there's a closing date of tomorrow. I myself will not be applying. If I am nominated, I would have to consider the nomination, but I myself have not applied.
So it's both a nomination and application process.
In this round, yes, you can apply, or persons can nominate you. I have no intention of applying myself. I didn't do that in the previous round, nor do I intend to do that. It is better if you are nominated. It also depends who nominates you, but I am not applying as Andrea Johnson.
Okay, but you'll consider it in the event you are nominated?
I will consider it, yes.
Okay. All right. Advocate Johnson, my sincere apologies. I think we would have also just wanted to have a broader discussion with you about IDAC. But there are contemporary issues which I think we need to clear up. I'll try and go through just some lingering questions I have on those before going to some of the more broader issues. After this whole discussion about the handing over of dockets, knowing what you know now, don't you think that Lieutenant General Sentemule should have informed you that SAPS was investigating this matter? Don't you find it strange that, on the 4th of November, the inspectorate gets these dockets, starts working on it. On the 20th, I think, of November, they ask legal service to look at it. Even before they get their report, General Sentimule is all over there saying dockets must move. Isn't that strange?
I agree, Honorable Sangoni. Even if it wasn't her, the inspectorate should have told me. The long story short is someone in SAPS should have alerted the Office of the ID that they were already looking, the reasons they were looking, and my requesting the docket interrupts a process, and they would appreciate that I stand back, which we would then have gladly done.
Okay, I'm not expecting you to answer for General Sentimule, but when she then picked up the phone and said to the inspectorate, give over those dockets to IDAC, she obviously knows that the inspectorate is busy with them and she is interfering and interrupting that process, right?
What I can indicate is by calling the inspectorate, she then knew that the dockets were there. I cannot talk for what she knew they were doing with the dockets. I can just say she knew they were there.
Okay, thank you very much. I'm sure General Sentimule will help us with that. So, Advocate Johnson, during the course of these proceedings, we've been putting forward an assertion to witnesses that we think the reason we are sitting here night on end is because of deep divisions within the top brass of the SAPS leadership. I want to say that right now, I think that these divisions cut across the criminal justice system, and I just want to hear your view on this theory that I have. So we've been asking about Mr. Brian Padayachi, because Mr. Padayachi, it seems, he was used to effect this very speedy investigation and what I think was a frivolous arrest of Lieutenant General Khumalo. Tell me, so you testified that by the time you took the helm, were you at IDAC before you became the head of the ID when Advocate Cronier was the leader?
No.
Okay, but you are obviously successor-in-law in terms of head of IDAC, right?
Yes.
Okay, so he's retired at SAPS, and in your document, you go to a lot of detail around his skills and expertise. Are those unique?
So those are the skills and expertise one requires of investigators. So be they DPCI or IDAC, we need investigative experience, and you need knowledge and understanding of the law enforcement environment. So that is what he had when he did come to IDAC back at the time, and they did serve us well in terms of investigations. And if you'd allow me, Honorable Sangoni, just for clarity, he didn't conduct the investigations in any of these matters by himself. There's a team of investigators and prosecutors, and everybody does different things. Different people take statements, some issue Section 28 subpoenas, etc. In terms of the conducting of the investigation, there is a team that conducts an investigation and more than one prosecutor that assesses the matter. However, when we effect arrests, and this is a general law enforcement thing, you will find that when an arrest is to be effected, search and seizure warrants are to be applied for, cyber warrants, bail affidavits. They choose within the team who must depose to that affidavit. And for those reasons, he is at the fore, but he is part of a team. I only just wanted to clarify. I'm not trying to justify anything.
No, I think I understand you, but I'm sure you'll appreciate also, Advocate Johnson, that our line of questioning is based on the allegations that have been put before us, which intimate that he was intimately involved. He was also involved in the arrest, wasn't he?
He was not at the arrest.
He was not at the arrest. Okay, only the investigation. So I was asking you, these skills that he possesses, are they only possessed by a person who has retired? Because I would think that if they were the requirements of the job, we're not creating job for retirees, am I right?
Honorable Sangoni, when I took office at IDAC, the issue was we had duty reassigned or seconded individuals. Many of them were already at an advanced age. When we started recruiting as well, the experienced investigators in criminal matters are of an advanced age. And that is the same answer you would get even if you talk to the DPCI and you talk to the detectives. And of an advanced age doesn't of necessity mean that they reach their retirement age. Many of these experienced law enforcement officers also left for different reasons before the time. But many of them are the more senior people, without casting aspersions on anybody's age. But the experience came from there.
But he had retired and was brought back or headhunted.
In terms of what I have from his statement and what we have from my finding him there, it is correct. He had come out of retirement.
Okay, so I suppose then the assertion that I'm putting to you, Advocate Johnson, is that you have this person who is employed in one entity in the criminal justice system, purportedly is retired. Thereafter, he's brought back. He comes into this other criminal justice system ecosystem, proceeds to investigate as part of a team, charge, arrest his former colleagues who include the senior officials and people that he reported to. At no point did anybody think that this was conflict of some sort, there was something strange here, no?
I can do no more than indicate the team scenario, and each one of them delegate the duties. He did not arrest Lieutenant General Khumalo, but he was involved in the processing of the co-accused who had handed themselves over to the South African Police Services. So he was part of a team. When you think about it, the optics don't look good, but there was nothing untoward.
Okay, Advocate Johnson, there's lots of optics that look funny here. So General Khumalo, General Mkhwanazi asserts is being targeted, right? So in December, they raid Mr. Matlala's house. There's then a fabricated case that they stole Rolex watches. Also in December, it is alleged that Mr. Brown Mokhotsi sends an SMS to the minister that says, yeah, now we've got something, we can finally charge Khumalo. Then in June, you arrest him. Sorry. So IDAC arrests him. Does this not look like a coordinated campaign against General Khumalo?
It doesn't, simply because you have to look at who is dealing with what. We were not dealing with, nor were we involved in whatever happened in December, be it for Matlala or for Mokhotsi, bearing in mind, Honorable Sangoni, that at the time we didn't even have the referral for the Matlala tender corruption matter. Ours dealt only with what came from Adams. If there was a concerted effort, then the timing of everything would have happened differently, logically, would have happened differently, and then we wouldn't have gone on what everyone goes on about is, what were you doing with what they allege is an HR or labor issue? We would have taken all those other allegations that are purported to have been made and hit him with a full book of allegations. That's not what we did. That wasn't our case. Our case was different, and we were not working hand in glove with anybody outside of IDAC.
Okay. But you can see coincidence, right?
Stinks of coincidence.
Okay. So just help me. Why, having now heard all of these allegations, are you not investigating them? Because when you spoke about your mandate, you said you are only limited by the extent of the mandate. You don't only investigate 90% of a thing, you go all the way. Now, why are you not investigating organized crime and drug cartels? Because your mandate says that you can deal with issues. In fact, I want to read it if I can find it. It's 9.2 somewhere. But in your mandate, you say that issues that relate to the Contravention of Prevention of Organized Crime Act, they fall within your mandate. So why are you not broadening the scope since your mandate allows you?
That part of the mandate, Honorable Sangoni, relates to matters of racketeering and matters of money laundering. That is where IDAC gets its mandate. Because in the corruption matters and or the financial crimes matters, there would be money laundering, as has been evident through the State Capture Commission, etc. Those, for us to prefer those charges and conduct those investigations, they fall within very specific provisions of the Prevention of Organized Crime Act. That is the purpose of having all of those parts of the legislation referred to. We did not want to run the risk that you do not mention a statute that we are allowed to deal with. That is what we do, and that's where we have restricted ourselves. But if there's organized corruption and it is reported, and if that corruption relates to organized crime, we can investigate it, but we don't investigate organized crime. I hope that clarifies.
Okay, now I hear you. So in your statement, and I'm going to tread carefully here because the chair did say he doesn't want us to discuss allegations, but I want to discuss the justification that you have given us. And I think some of the members have already touched on this. But you quote Justice Zondo that state capture is a project where a group of actors, their network of collaborators systemically conspire to redirect state resources for their own private gain. Then in paragraph 3.1, paragraph 38, you then list the elements of what make up state capture. In 1, you indicate that state capture can manifest where there is a conspiracy to redirect resources to correct purposes. So now, how was this accused number 7, Mrs. Mokwele, going to do this? How was she going to redirect resources for corrupt processes?
Just for clarity, Honorable Sangoni, I took that entire definition and all of the elements. Not every one of those elements are applicable to all of the accused.
You will indicate. So
in terms of...
she was not going to, I'll go through them. So she doesn't fall within the conspiracy to redirect resources for corrupt purposes.
The allegation that we make is she was put in a strategic position so that when she was requested to, she would redirect resources or funding for the resources because of the nature of TSS, their funding and what it is they can procure.
Okay, I want to be clear and again, very careful. Are you speculating that she will be in a position to do that, or you then have, I don't need to know the evidence, you then have evidence that that is what they were plotting to do?
We have evidence that that is what were plotting to do. And I did say it is unfortunate that I'm unable to discuss the other matters, not
okay.
just these two matters. But when you look at the full ambit or basket of matters, Honourable Member, then they do give you a different picture.
Okay. Then on the next one, which is the strategic appointments and dismissal, right? So Judge Zondo says this entails the filling of posts with loyalists who would then facilitate capture. So is it your evidence, and I don't want to know your evidence, that Ms. Mokwele was going to facilitate capture of crime intelligence? The co-accused. Okay. And then the manipulation of procurement is what you were talking about? Okay. I think Honorable Mngangwa has already asked you about the systems and processes and private interests and so forth. So if these are all the issues, then, Advocate, why would you then go and charge him on employment-related issues when you have evidence that there is a conspiracy to capture crime intelligence? Why don't you go for the jugular instead of confusing all of us with employment matters?
This particular point is its own standalone. When we have the other matters, we have to look at whether...
Mike, please, sorry, ma'am.
When you look at this matter, I must be tired if I keep forgetting the mic. I do apologize, Honorable Chair. This was a matter that stood alone. I did indicate that we had to first look at which matters can be prosecuted on their own. When we look at the balance of the matters, we have to look at whether or not some, if not all of these accused and other persons did not act as a criminal enterprise to conspire and further the ends to which we allude. And that is part of the prosecution and investigation strategy.
Okay.
Not every matter would fall there, but the remaining matters are exactly what we have to consider.
Okay. So you've also said somewhere that there are persons who have been appointed that allowed the head of criminal intelligence to access funds without proper processes. So who are these people? How come they are not charged? Like, what happened to that? I mean, it's a big statement for Madam IDAC to make, and people are roaming around free.
So we also have, that would be the seventh matter, which is a Langlaagte matter, which refers to procurement, which is also under investigation. It hasn't fallen under the radar, Honourable Member.
Okay. I was going to ask you, but I think I'll ask it anyway for the sake of completeness. Is this matter of Lieutenant General Khumalo the only matter that you have dealt with which relates to manipulation of employment? Is there precedence for this? Because, is there precedence for this? Has this ever been done?
In IDAC, this was the first one that we had done. I can't answer for if it was done in the rest of the NPA. It's something I would have to find out, or else I would be misrepresenting facts, which I cannot.
Okay. On paragraph 29 of your testimony, you indicated that so you speak glowingly about crime intelligence, then that you indicate that the key challenge in relation to crime intelligence is the use of funds and the lack of accountability thereof. Drawing from your experience, and I think I want to step off these contemporary issues now, but drawing from your experience, what recommendations would you have to tighten the Secret Service account, the slush fund? I mean, we asked the minister, he said, yeah, I don't know. What recommendations would you have? You've been through the Celebi matter, the Lazarus matter, what you call the Lazarus Mdluli era. What needs to be done there?
Honourable Sangoni, I did indicate earlier that what one should do is allow greater latitude to the Inspector General for them to be able to openly look at the books and to be able to account cent for cent and legitimacy, whether it is of procurement of goods and or services. But the same should be allowed of the Auditor General. And I am saying we do have bodies that can do it. We have to find a mechanism, given the covert secret nature of this account, to allow them to do that. It might then mean that the Joint Standing Committee on Intelligence is going to have to sit down, have a debate, and perhaps seriously consider an amendment to the legislation. There is a protection, and they then have to ask the question, what is this protection doing for the fight against crime and for accountability and transparency? I think that might work.
Okay, I'm almost done. One of our terms of references speaks to us investigating prosecutorial conduct between IDAC and the KPTT, Political Killings Task Team. I just want to make sure that I heard you right. IDAC has no relationship with the PKTT whatsoever. We can scratch that off our terms of reference.
Absolutely. I can say that with both my hands raised to God. There's nothing we have to do with PKTT.
Okay. And then what is the conviction rate of IDAC or ID, then IDAC?
Sorry, we had in this year, we've had 1, 2, 3 so far. The unfortunate thing about these matters is they take such a long time. They even frustrate us that they take so long. But it's usually lots of accused, lots of lawyers. And I know what the South African public wants, and they're absolutely entitled, Honorable Sangoni, to want speedy justice. But unfortunately, these are voluminous matters, and they just simply take forever. What we have done is we have engaged with the National Director, and I am aware that there are engagements that, if they haven't already happened, will happen with the Honorable Chief Justice to ask for a fast, I'll just use the terminology we used, for a fast lane court. We're not asking to create special courts, but to say when we have a state capture matter that must go on trial, the JP of that division must know this is state capture. They must get a judge who will then sit in a dedicated court to run with the matter start to finish. The chances of you finishing some of these matters within 6 months to a year, as opposed to the 5 to 10 years that it's taking us because we are given space on existing court roles, specialized commercial crime, as well as the regional court, and we also, Honorable Sangoni, have to fall into the high court role. It is not ideal, and it is impractical, but I am aware that there are considerations for what they call a fast-track court, experienced, dedicated judges to run start to finish.
Okay, yeah, I was going to ask you what needs to be done to fast track it, but then even if you've got a fast track court, you get in there and the public believes, well, I believe that you get there and then your things are thrown out. Like, what are you going to do about that? Because that also seems to be a problem.
Well, for us, first prize is finding a court that will only deal with IDAC state capture matter that is brought before it. But at the stage it gets to that court, it must be trial ready. So all of the other processes and whatever motion applications are brought must be dealt with by court of first instance, so that when we go to the Chief Justice or to the JP, we are saying all the parties, including the defense, we are ready. We want the judge to start our trial. And that is what we have to aim to do.
Advocate Johnson, I know maybe I'm unfairly targeting you because it's the NPA generally, but can you understand how frustrated people are that you would bring cases, and I'm sure it's both sides, you know, both the accused and members of the public, you bring cases, nothing sticks, you have to go back, and it looks like the NPA/IDAC is just fumbling cases and people are losing confidence in the system.
Honorable Sangoni, I take what you say. In terms of the IDAC matters, I know that we did have an unfortunate incident in terms of the New Lane matter. And without discussing the trial judge, I think the Supreme Court of Appeal judgment speaks volumes on what went wrong. It has cost us a lot of time. It's cost us over 2 years to get that judgment. Now the same accused, when we were ready to enroll the matter, have taken us to the Constitutional Court. Accused persons have rights, and so they do exhaust them as they do. But are you asking if the NPA can do better? Of course, that is what we were supposed to do. We must aim to do better.
Are you working on doing better? What is being done to improve the output? Well, yeah, I'll call it output of the NPA.
So if you look at the IDAC matters, I've indicated what we seek to do. And we seek that when we enroll a matter, that at the date of enrollment, all the investigations are done and we are ready to make disclosure of the docket, which then becomes very important and determines then the speed at which that matter becomes enrolled. And that has become a general principle with the commercial and corruption matters that are also dealt with by my colleagues in the DPP offices and specialized commercial crime.
Okay, I'm gonna step off this, but I do have to just throw in this one thing. Do you think that, I mean, you spoke about the implications, right, of things that, let's say, General Mkhwanazi does. Do you think that the NPA should take any accountability when they do bring matters to court, the matters are not ready, and people lose their livelihoods because the NPA bungled things, took them to court, they were not ready, people lose their jobs and all sorts of things? Or is the way that it is now okay? It's like, oh no, we'll do better.
No, it cannot be business as usual. And what you say is exactly how it should be. And that is why I was at pains to say, you know, when you just even mention who might be a suspect, the irreparable harm you do, no one cares that you didn't end up charging Mr. or Mrs. X. They remember what you said. And that is the same for matters going to court, matters then being withdrawn, and those matters then falling by the wayside.
Okay. I think it's even worse when you charged, you know, and not just mentioned, but I get your point. Honorable Johnson, has in your experience, both as, okay, I won't go to the Scorpions, but as a prosecutor, let's say in the last couple of years, has there been political interference in your work? Let's say especially the ID and IDAC, and could you give us the details of that political interference?
So we won't talk about the DSO because I think that is history written. But since then, I myself in my work environment have not had political interference. Of course, we had members of the NPA where there's allegations that they had been captured, and many of us, myself included, were victimized, where we were not allowed to deal with our matters at all. And we were moved office to office. I mean, I was physically moved in one building 4 times at the women fancy of one of the national directors. At a stage, I ended up working out of my boxes because that was the best thing for me to do. In my time in IDAC, not then Minister Ronald Lamola, not Minister Simelane, and not the current Minister, Mayor Mamoloko Kubai, have sought to interfere in the work. They have not asked me as IDAC to provide them with details of the merits of matters. They have not asked that they be informed when persons will be arrested, because that is where you would look at for interference. However, all ministers are entitled to ask for a high-level report in terms of Section 33 of the NPA Act. I think there was only one instance where a report was provided to the Honorable Minister Lamola at the time. There was nothing untoward about it. It was more clarity, but none of the ministers since then either have asked, which they can legitimately ask for.
So the lack of prosecution is not because you have politicians, ministers interfering in your work and saying, do not prosecute this one, frustrating you, things of that nature?
Our challenges are different. They are not political interference.
Thank you very much. I think my second last question, if not the last question, okay, I've forgotten this. Let me go to the last question. I was worried about your response, Advocate Johnson, when you were asked about the duplication of functions. I think it was, I'm not sure if it was Honorable Cameron or Honorable Klopper who was proposing a protocol. Now, when Minister Kachalia was here, he went to great lengths speaking about this duplication, scope creep and whatnot, right? Now, your response suggests to me that you think that the criminal justice system should be run on collegiality. We must just speak together more. We must just do this and this. And I'd really want you to think about this duplication. Minister Kachalia proposes, for example, the establishment of an OPI, I think Office of Integrity, Public Integrity or something, which would then look at IDAC, which would look at the Hawks, the SIU. Don't you think a mechanism like that could strengthen the fight against corruption, in particular crime in general?
So my response in terms of as it stands, and because there isn't a coordinating mechanism, that collegiality was the only way we were able to get over those hurdles. I have seen the NACAC recommendations, and they make sense, so much so that there isn't a straddling of mandates. So the DPCI, as per those NACAC recommendations, ought only, if they are accepted and go through Parliament, only deal with organized crime. And that matters of corruption, serious economic offences should fall within the mandate of IDAC. And in terms of the OPI, it is almost an absorption of the SIU, but with a bit more functions than which they currently have. I think that would talk to a bringing of all the law enforcement, aligning the mandates, keeping mandates restricted and effective, with the detectives still having to do the lower level crimes. And what they also then put in there, which is what we don't have, is a coordinating body that will look at the cases that are coming in, who's doing what, and how we can perhaps help with the resources, etc. So for the first time, there'd be a all-round coordinating mechanism. And I think if we give it a try, the chances of it doing us greater good would be.
Okay, thank you. Chair, I'm done, but I just want to ask Advocate Johnson before I step off. Advocate, we don't want another 6th of July media briefing. So I want to ask you here, right, that where you are sitting, and I'm sensitive obviously to the last part of your statement in terms of threats. Are you sitting in a position where your life is being made difficult? I mean, in terms of the work of IDAC, that you can't function, you have all these syndicates, influences, interferences that make it difficult for you to do your work. Because I won't come back after you answer that question, could I also request, if possible, in writing, any recommendations you would want the committee to consider to strengthen IDAC or even the criminal justice system in totality? Are you going to do a 6th of July on us anytime soon?
I didn't do a 6th of July, but a 6th of July was unnecessary. However, I do not know what attempts Lieutenant General Mkhwanazi made to escalate, got no joy, as he says. And when people are frustrated and their intentions are good, sometimes it comes out in the manner that it came out. But in terms of the death threats aside, I am able to do my work. It's a lot on one's shoulders. You cannot forget it. You can't just, I don't relax. There's no relaxing and just getting to work. So one would have liked me to be the me.
The time of the members expired.
Thank you, Advocate Johnson. And I'm happy that you're not frustrated. Thank you so much for sharing your time with us. Thank you.
Thank you.
Honorable members, can I check those who want to make follow-ups? Honorable Matthews, Honorable Sauls will be the two speakers. The list is closed.
Thank you, Chair. To follow up on the issue of political interference, I just want you to speak a little bit too. So you said you haven't had any political leaders, ministers, etc., come directly to you. Politicians, by nature, if they are not clumsy, they're not going to come to someone that they haven't captured yet. And do you think that the issues that you are having, because you said you do, or you have worked under, and you still do, under very trying situations, they have to be fueled somewhere, because it's no way that just bureaucrats can do that without being protected or being fueled by politicians in the background. That's my statement. I would like you to speak to that. And I'm not saying that you must identify any politicians, but that is a fact. There's no way bureaucrats can get away with half of the things they do if they are not in the pockets of politicians or being directed by politicians.
You put it so eloquently, Honorable Matthies. I'm not sure what response I'm able to give. Safe to say, I have had concerns ever since the death threat and the 6th of July media briefing. And I'll tell you why. What you see is what you get. I don't know how to be different. Andrea Johnson or the ID. And so when people were in the public space connecting dots that I didn't even see, I had to ask myself the question, who are you and why? And is it necessarily the person who took to a podium? I still don't have the answers. I do have a suspicion that something bigger is aimed at targeting, if not IDAC, the ID. But that is where I put it on pause. Unfortunately, I do believe the Lord will show them up. It may sound philosophical, but that is all I can wish for. But I do hope I find the sources in IDAC, because that would also give an indication of what the agenda is and who's running it.
One day is one day. And can we safely say that state capture has continued under President Cyril Ramaphosa? Because these cases we're talking about are post-Zondo Commission.
I cannot say that state capture happened under a specific person, because that person is not implicated in any of the cases IDAC currently deals with, except that capture continues. It even happened after the Zondo Commission with the PPE procurement. Corruption is rife. That you cannot take away. I can't attribute it to any one specific person other than the people whom allegations are made against and whom IDAC would have to investigate.
Now, I wasn't saying the person, administration, so the Cyril Ramaphosa administration, but you've answered our question. Thank you, Admin.
Thank you.
Yeah, just to remind members, President Cyril Ramaphosa, we elected him here in June last year, and by an overwhelming majority. My friend, Honorable Sauls.
No, Chair, I can't be your friend. You are my elder. You are my senior. Too much respect for you to be called your friend. Honorable Chair, Honorable Advocate, we just got information on recruitment. The follow-up is on the recruitment. Just got information that there was a post of senior criminal investigator that was advertised 2024, and the appointment was made this year, 2025. A colored female, LLB degree, many years of experience, applied, and those who got appointed has less experience than her. And then she was victimized when she wrote a grievance or lodged a grievance against these unfair appointments. So I want to put it to you, we can prove, and we want to debunk the notion that coloureds do not apply and they do not qualify. Earlier, I didn't have this information. I received it now. And I put it to you that IDAC must do more, because coloureds, there are coloureds out there that qualifies and that can contribute to the well-being of this country.
I take note. There was a labor dispute that was declared. I'm therefore not going to discuss the matter. Safe to say it is a one-sided story that the Honourable Sauls has been given, and it is unfortunate. but I do know what you are talking about. But the person had declared a grievance against myself and various officials in IDAC. I'm therefore unable to discuss that matter. But I do know what you're talking about, Honorable Sauls.
Can I just say that I obviously don't know the details, and that's not important for me. What is important for me is you can confirm she's colored, she has qualifications, and there are colors that applies. I just want to debunk the notion that colors don't apply and they are not there qualified. That's the issue here. Let's do more to be inclusive, because there are colors that are professional and do qualify. That's the point.
I'll take your point.
Honorable Nomvalo, your time starts now.
Thank you, Chair. I don't think I will be long, Chair. Good evening.
Okay,
good evening,
just hold a moment. We get Honorable Malema.
I don't know, Chair, but I think it's unfair on the witness to use one incident to create a phenomenon that is non-existent. Because it's very unfair on her to say, because of one incident, colors are applying and they are not being appointed on the suitable cases. So from that point, I think we should protect her. She gave us her answer on the matter, and that's her answer. We can't use one isolated incident to want to prove a non-existing crisis.
No, Honorable Sol, wait, I don't want that. I don't want you to debate the matter. The reality which has been presented here and which has been acknowledged is that there is an underrepresentation of colored people in IDAC. And I think it's a matter which we should be worried about. And if there is a way, persuade the leadership of IDAC here to pay attention to it. They have been excluded for many years. And I think it's very important that we look at that. Honorable Sauls might have lacked a better way to present it, Honorable Malema. But the truth that remains is that the colored population of South Africa also deserve recognition. It's very rare that you see them in any of the state departments, especially at the highest echelon of leadership. So the point, Honorable Sol, I think has been driven home, and we must take it as such.